Well, ladies and gentlemen, it's Saturday. It's February the 28th of 2026. This is the Court Gallery, and this is the Weekend Review. Can the titles get any longer, I wonder? I probably so. Give me enough time. I'm sure I can think of some stuff. Ladies and gentlemen, we're all over the place today. We're in Michigan, we're in Wisconsin. I think we're going to Ohio for a sitting. We're starting with Judge McNally. This is all cutting room floor stuff, people. You've seen all the stuff I've been putting out all week long. This is the stuff I didn't have time to put in the shows, and a little chunk of Judge Simpson's landlord-tenant docket from yesterday. So, buckle up, ladies and gentlemen. It's all good. It's all a little bit crazy and very interesting. And it all starts right now.
We also have one in Woodhaven.
Anthony, all right, let's just take one at a time here. Anthony William Rose, 25F244639. Mr. Rose, your name?
And
Rose.
385, Judge.
You know this is Judge Hessens, right? Everybody knows that. It's fine.
I can take that over.
No. Your name, sir?
Anthony Rose.
All right. Well, where's he been? He doesn't like to show up.
First of all, good morning. Your Honor, I had wrote something on the Register of Actions, housekeeping.
Did the audio die for everybody? What the heck is going on? The heck is going on? I am working on the audio currently. Ladies and gentlemen, we have ourselves some technical difficulties. Bear with me just one moment. My VLC has completely crashed, which is not something you see very often. Sorry about this. I have no clue what's happening. Oh my Lord. This is a very inopportune for this type of thing to happen. I I'm actually kind of lost at what to do here. Okay. Help. Yeah, what the heck is going on right now? I have never seen anything like this in my life. Bear with me. Slowly getting there. I'm adding a new capture. I'm adding a new source. Oh my Lord. Oh my God. Oh gosh. So something's happened and I'm having to think on my feet and it's not working out very well. And so basically I play these videos through media player. And my media player has crashed completely. Well, play. Just play, for God's sakes. Will you please play? Golly, the things.
We also have one in Woodhaven.
Anthony, all right, let's just take one at a time here. Anthony William Rose, 25F244639. Mr. Rose, your name?
And
Anthony Rose.
385, Judge.
You know this is Judge Hessens, right? Everybody knows that. It's fine.
I can take that over.
No. Your name, sir?
Anthony Rose.
All right. Well, where's he been? He doesn't like to show up.
First of all, good morning, Your Honor. I had wrote something on the Register of Actions housekeeping. I added the apartment number and I changed Monroe to Lincoln Park LP to properly reflect the address that was not listed correctly on the register.
You know how many times you failed to show up?
Yes, Judge, today's the date and time set for an arraignment for Mr. Rose on files 385 and 639. Mr.
Oh my
Rose,
goodness.
Bear with me here.
There we
He
go.
already pled, it looks like, and it looks like he's here for he's going to be sentenced.
Correct, yes.
So I should just set about a $10,000 cash bond and set this for next October since he doesn't like to show
Thank
up,
you,
right?
Your Honor.
I'm so sorry. I'm
No, you're
sorry.
not. Don't tell me you're sorry. You missed about 4 times here. Maybe that's what I'll do. I'll set a big high cash bond, and then you can sit there for 8 months and think about why you act like a fugitive and continue to act like this. 5,000,
Thank you, Judge.
10%. Well, I don't know. Was he posted that before?
No, I didn't see that. I saw where you put the that on with the 10%.
Boy, you got to grow up. How old are you? 6?
36, Your Honor.
Oh, okay. Well, you're about acting 30 years younger than you really are.
So for purposes of
I'm just
my client,
been
yes,
busy
formal reading.
taking
You've
care of my
been-
mom. Like my mom's really not doing well, so I've been taking care of her.
Where was he picked up, officer?
I believe it was in Lincoln Park.
Whereabouts in Lincoln Park?
That I'm not too sure of. I
picked
just know
up
we were
last time?
contacted by Lincoln Park.
I was
Where were you
picked up by my mom's house.
Why were they where were the police there?
Me and my brother.
Well, you got in a fight or something?
No, me and him were getting in an argument, and he's like that.
All right. Can Judge Hudson take this today? You guys, can you find out if she can take this or wants to take this today?
I'll check on that, Judge.
And Your Honor, I can take care of that for Mr. Rose once we get Mr. Caballero resolved.
Mr. Caballero's another one here, huh? He's going to be one of these guys on the list again. I mean, the guy never shows up.
I'll take care of Mr. Rose's sentencing today after that.
I just don't know if she can do it or not, so I'm trying to figure out. Jennifer or Linda, can you find out? You know what? I'm gonna let them deal with this. I don't know what to tell you.
Jen is talking to Lisa right now, Your Honor.
Yeah, I don't know what
About
to
it.
do on this. Oh, wait. They've just got March 12th.
Yes.
We don't want the guy sitting in custody until March 12th, do we? I mean, even though he's been very disrespectful, Mr. Rose, you know, I still have a function and a job, and I'm not going to be vindictive, just because you act like a little child. And that's the truth. So, how many warrants you got? Tell him I don't want to go to March 12th. Will you, Jennifer or Linda? I tell them I've got this
Your
guy
Honor.
here. If they want to just call Flat Rock and tell them what the sentence date is, that's fine. But I got to move on here. I've got people here that have been waiting.
There may be a PSI report that may need to be done.
This,
I
I don't know what she ordered. I can't tell. It looks like screening and assessment. I don't know if he underwent the screening and assessment. Did you get screened and assessed by probation?
I went to probation and filled out all the paperwork. Yeah.
check with probation and see if there's a report ready. Judge, I can take care of that. I can go down to Judge Hudson. I apologize. What?
No, it's okay. I didn't know. I was just pointing out that it was hers. And I didn't know that all these guys were in custody of Flat Rock. It's fine.
Okay.
I just need an answer from them, Linda. Would they please give me an answer?
What would you like, Judge, as far as
I
you
don't
to see
want
if
the
Judge
guy to
Hudson can
have
see
to
him?
wait in jail till March 12th. That was written on the front here. I don't want him
Okay.
to have to do that.
That's the next Flat Rock date, is what I was told.
We don't
So,
need a Flat Rock date. He didn't show up for sentencing.
Okay. I will
And
get
he
back with you in
said
just one moment,
today.
please, Judge.
Well, I'm just passing this. You guys can figure it out.
I'll
How's
figure out
that?
to talk to probation, see if we got the report.
Thanks.
And Judge, we have the others as well at the report.
I get it. So that's what we'll do. You'll hear from them and they'll tell you, I guess. I don't know what else to say. Hamza? The dog,
For the
law,
law.
25W39293.
Attorney Mike Bolden, 7, the reigning attorney. Sir, as you approach the podium, come on up, sir. It's okay. And just.
Are we all set, Your Honor?
Keep your hands on
On just that one, I think we got other ones with these guys, don't we?
On Anthony Rhodes?
No, he's the only one in custody, Your Honor. He was just asking if he was also.
Is Joseph Bills in the courtroom?
He is.
Yes.
Yes, sir.
All right. Do we have, you're all set on that one. My apologies. You're going to hear from them as to when they're setting the sentence date. Okay. Anthony William Rose.
Who you calling?
Yeah, Judge, it's gonna be Joseph Bills. Rose was the in custody.
I know, but we got to get Flat Rock back on. There's a second file here.
Yeah, and I put that on the record. I mentioned that.
I didn't know. I didn't make anything. Joseph, We got to get Flat Rock back on. Can somebody call Flat Rock with him? Joseph Wayne Bills, 26G 702074.
Your Honor, for the record, arraignment attorney Mike Baldwin, P 65417 on behalf of Mr. Bills.
Do I have a police officer from Gibraltar on Zoom?
Joseph Wayne Bills.
All right.
Purposes of arraignment today, Judge, my client stands mute, waives formal reading of the general information and complaint. I give you just some very brief background.
Just give me 1 second here. I need to know if is Gibraltar out there? So he's charged with,
Well, July 3rd, enhanced notice, driving while license suspended second, and high BAC .17 notification. So this is a felony, Judge.
all right, I get it. I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer at all subsequent court proceedings. You have the right to a probable cause conference and the preliminary exam. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, people will have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, they'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes, Your Honor.
So your probable cause conference will be March 3rd at 9:15. Preliminary exam will be March the 10th at 11:30. Do you happen to know, did anybody call Gibraltar on this? Do I have anybody from Gibraltar out here on this, on Joseph Bills?
I don't think so, Your Honor.
We'll call Gibraltar now,
Nah,
Judge.
that's okay. Well, it wasn't your responsibility. I'm not suggesting that, you guys. Let's just address the bond here. Does anybody, they're here?
Yep.
I just want to ask him a couple questions. Officer, I'm so sorry about the other, this Mr. Rose again. I got case number. And I see now what they're telling me makes more sense too. Because he's put himself in a bad position now. All right.
Yeah.
All right, let's talk about bond. Gibraltar,
They're in there.
come on in, detective. Talk to me. Tell me your name, Detective Robinson, and tell me a little bit about the case. I want to know what the blood or breath result was. Thank you.
Yes, sir. I'm bringing that up right now. I just got the call to come in here. Sergeant Gary Robinson, Gibraltar Police Department.
Okay.
I'm going to need just a minute. Sorry about that.
That's all right. Take your time. I'm going to let him address bond while you're bringing up the information. I've already told them that the PCC is on March the 3rd at 9:15 and March 10th at 11:30. The preliminary exam.
And there was a police report, I believe I saw in there.
Yeah, but I don't, that's not appropriate for me to look at.
Yes, I understand that, Judge. Thank you. Judge, my client is a full-time employee at a gas station. He takes care of his grandbaby when the parents are unable to do so. He's got a little bit of history of not showing up for court, and I'd like to just bring that out on the table straight up front. But he's here with us today, and he's here to address the matters.
Does he, how much does he make in his employment?
I make roughly $400 a week, Your Honor. Give or take, work roughly between $30 and $40 a week at my job. And
How old are you?
I'm 52.
All right, can you tell me, Detective Robinson?
It's open up right now, sir.
Okay,
So I believe his was a crash West Jefferson, Middle Gibraltar Road. He hit a guardrail. The officer showed up. He's intoxicated. Let me look at his blood. His blood was a 233.
5,000, 10% is his bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to attend AANA at least 3 times per week. Now, can you post the 500?
I can post the $500.
All right.
I had to get.
Hang on. Let me finish. I can do one of two things. I can either order you not to be released until fitted with a SoberLink device, or I don't know how you got here today because you have a revoked license. Somebody would have to drive you out to Macomb to get a SoberLink device. You're going to have to pay for that. If you're telling me, Judge, I've got the money, I can pay the 500 bond now, and I've got the money to go out to Macomb, and somebody can drive me right after this hearing, then I'm going to let you do it on your own. If you don't have the 500 right now, or if you don't have somebody to give you a ride, I'm going to have to order you to go to the Wayne County Jail and that you not be released until fitted with a SoberLink. The problem if I do that is you're going to be sitting in there for 3, 4, 5 days. You got it?
Yes, sir.
You have the 500 with you?
No, sir. I could, if I'm able to contact somebody, I can get it.
He can use the court phone system, correct, Judge, to make some calls?
Yeah, we'll let them make calls, but they got to rush up here. We're not holding you in this facility for more than a half an hour or so.
Yes, I can't say.
Are you 100% sure?
98%. My wife is just waiting for me to call, but she's the one that's taking care of my grandbaby today due to the fact that I'm not there. You're taking care of me.
Call, go out in the hallway and call. Do not leave this building though. You understand me, right?
Yes.
I'm going to extend that courtesy to you. I'm going on to another case and then you're coming back. But you are also defendant to obtain SoberLink device by the end of the day. So I'm going to let you, that's a condition of your bond. And if you don't follow this, you're going to have a big problem. You still live on Cornell?
Yes, sir.
You go out in the hallway and you call your wife and you come right back in here, okay?
Yes, sir.
Thank you. Now I see what the problem was on Mr. You're all set, Detective.
Thank you, sir.
Anthony William Rose, 26F245-385. Now I know what the problem was. Your appearance again?
Thank you. Arraignment attorney Mike Holden, E65417.
All right, counsel. Does he stand mute on this other disorderly public intox that I just discovered that I have?
385, yes, Judge.
All right. Well, you got a problem now, Mr. Rose, since I know your name again.
Anthony Rose.
Since I know that you don't show up in court, $2,500, 10% on this case too. And you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I want you to give him an AA verification sheet, officer. If you don't have one, we'll give you one. No alcohol, no marijuana, no illegal drugs. You're to attend AANA at least twice a week. You have to go in person. No alcohol. You cannot have any contact with prosecution witnesses except through your lawyer. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes, Your Honor.
Judge, can he also, I believe that the police department will have the court appointment
Yeah,
form?
yeah, give him the court-appointed petition to fill out too.
Cool, please.
And the problem is now you got a March 12th date. You keep playing games with the system. March 12th will be your pretrial. That's the earliest date I can give you.
So that's resolved.
But he didn't show up on this one either, March 12th at 10. Stop acting like a fugitive, okay? Will you please?
Yes, Your Honor.
Where do you work at? Do
I
we
work
cover
in my
that
mom's.
already?
Yeah, I've got this.
Where do you work at?
I work in my mom's co-op building in Lincoln Park. I do janitorial.
Okay,
And he's also taking care of his mother at this facility.
all right. Good luck. Thank you.
Thank you, Judge.
We will go on the record in the matter 25 CM 130 and 131, State of Wisconsin versus Jacob Oyat. The state appears through District Attorney Kevin Schmidt in person. Mr. Oyat appears in person with his counsel, Nicholas Davis. We're set here today in this matter for a plea and sentencing. We also have 26 GF 28, but I believe Mr. Schmidt informed the court that that isn't going to be a non-prosecution case and to be dismissed and read in this matter.
Yes, as an uncharged read-in.
All right, thank you. And so the parties have reached an agreement. Mr. Davis, can you please recite the agreement for the record?
You can go ahead if you want, Kevin.
What?
You can recite it if you want, Kevin. It's a misdemeanor battery, Your Honor, with a domestic. It's my understanding it's a year probation, court cost fine, DNA surcharging, whatever program is required, he has to do it.
And he needs his driver's license still?
He does.
Okay, all right. And it doesn't matter which one he's pleading to, aren't they both similar?
They're both similar, whichever one you wrote on there.
Whichever one I have on the sheet.
They have both cases on the sheet.
130.
130?
Let's do 130.
Okay.
All right. So, Mr. Oyat, you went over a plea question or waiver of rights form with your attorney, is that correct?
Yes.
And did he go over it thoroughly with you, essentially word for word?
Yes.
And you looked over that document and you signed it?
Yes.
And you understand everything?
Yes.
You are 26 years old, you have 12 years of schooling, you can read, write, you understand the English language, all correct?
Yes.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
No drugs, no alcohol, no mental illnesses or disorders?
Just mental health, but
And do you take medication?
yes.
And do you take it as prescribed?
Yes.
Does it interfere with your ability to comprehend or understand?
No.
So you're in a position right now where you fully understand everything.
Yes.
Now, did your attorney thoroughly go over your constitutional rights?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that you're pleading guilty in 25 CM 130 to count 1 misdemeanor battery with a domestic abuse modifier?
Yes.
Do you understand that the state would have to prove on or around July 21st, 2025, you caused bodily harm to AMD by an act done with intent to cause bodily harm to that person without that person's consent, a class A misdemeanor? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you also understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the agreement that's been recited on the record?
Yes.
And that it would be for a recommendation of 1 year of probation?
Yes.
Do you understand I'm not bound to follow that, meaning I can sentence you to any sentence that I believe would be an appropriate sentence?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yeah.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, the section called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did cause a misdemeanor battery without having AMD's consent?
Yes.
Are you guilty of this crime?
Yes.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or promises to you, Mr. Oyat, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
I have a court date next month. Is that still ongoing?
With
No.
these actions?
No.
This should not, with the new case that you were charged with, that's going to be dismissed as part of the deal, okay?
Okay.
All right, any other questions?
No.
Okay. Then as to count 1 in 25 CM 130, misdemeanor battery with a domestic abuse enhancer. But first, you understand with the domestic abuse modifier that upon conviction, you face a $100 additional surcharge,
Yes.
and you could face the federal prohibition to no longer being able to use or possess a firearm for life.
Yes.
Okay. As to the misdemeanor battery with the domestic abuse modifier, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 in 25 CM 130, the remaining count and the other open case, along with 26 GF 28 will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Victims' rights compliance.
Yes, Your Honor.
Any restitution requested?
It'd be in the report.
Don't think it was in
No,
either
I
of
don't
them.
think so.
Okay, in either case,
Double checking the second one out. Our computer is just very slow. No restitution in any case.
okay, all right. Argument, Mr. Schmidt.
You can summarize what Mr. Oyat needs pretty easily. Alcohol ruins his life. Every single one of these cases, including his past cases in our county, has been him consuming alcohol and either starting a fight or engaging in erratic behavior that triggers someone to start a fight with him. One of those two. If he were actually able to stop consuming alcohol, I don't think we would ever see Jacob here ever again. That's why we need this probation. We need him to actually tackle that. The younger someone is, when you start dealing with something like that, the more likely you're to be successful. And I think with him being only 26 years old, we have a good shot of that now. Thank you.
All right, thank you. Mr. Davis.
The DA's 100% correct. When he drinks, bad things happen. What really strikes me is I try and get the time to know all my clients as well as I can. And I got to talk to Jacob and I asked him questions as I would with all my clients. And he's to the point now that he's damaged his body. The doctor even told him if he continues drinking, he's going to die. His liver is that of some person that's been drinking their whole life, copious amounts. So his health is, I mean, it's not just doing silly and foolish things. It's now a matter if he wants to live and have a great life. He's young. He's 26 years old. When I talk to him, I guess I'm hopeful that because of that and because he doesn't want to drink and because of all the problems that surrounded that, I hope that he can move forward. I know that there's issues that force a person to want to drink, and I know that he's dealing with that. A lot of things, that traumatic stuff that's happened in his past that he's explained to me. But he's an adult now. He needs to move on, and he's got to just work and not drink and enjoy his family and his life. And if he does those things, he's going to have a very gratifying life. But the health thing, that is just really shocking to me when he told me that he's that young and that he's already got those issues because of alcohol. That was very shocking. And so the good side to this is he's an honest person. He's not a liar. He's been extremely polite, punctual, always for every appointment we've had or meeting or phone conference. And you can't meet a finer person. But again, Judge, I've never spent time with him when he's drinking. So, and I don't want to, because if he turns into a different person, then he's probably not pleasant and polite and intuitive. But what you see here right now is the person that I know, and he's a fine young man, and I think he's got an ability, and I think he will be successful. And so I sit here very proud of him right now. And I just hope that he pushes forward and really abstains from alcohol, not just because of a probation, but because he wants to live. Thank you very much, Your Honor.
Thank you. Mr. Oyat, anything you want to let me know, you want to tell me?
No.
Mr. Davis, you have said all of the things that I know to exist about Jacob. I've known him since he was 17 or 18. I've known him a long time. You're a sweet kid, but knock it off. Stop.
I know.
Jacob, stop. You really are. Now, from the time you were young, what have I told you? You're smart, right? And you've showed me you're smart.
Mm-hmm.
You're kind. You're caring. But when you drink alcohol, you become a beast. You become somebody that no one wants to be around and no one should be around because you are uncontrollable. And now you have damaged your body. Jacob, you're 26. I don't want to see or hear about your funeral in a few years because your liver gave out or something happened, because people do die from alcoholism all the time. Young people, 30s, 40s. I know you're not yet 30, but you're almost there. It's hard to imagine. Gosh, you're making me feel old today. But Jacob, it's time to grow up. It's time to man up. And it's time to take care of yourself. And it's time to stop, because even when you are drinking, you and your sister, you go crazy. But I know you love each other when you're not drinking, right?
Mm-hmm.
And you know these things I'm telling you are true, right?
Yes.
I want to see you succeed. And I've told you that from day one. The very first time I started seeing you, I've told you that. And I see that. And Mr. Davis doesn't lie. I mean, he will tell it like it is, even if there are things that are not so lovely about his clients. He lets them know, he lets the court know, but he's like, well, but they're willing to do this, or they admit to this, and all of those things. He's saying nice things about you, and he's saying because they're true. So you have to start believing them yourself. You have to start taking control of your life. And you have to be the Jacob you're meant to be. This is not, well, this sitting here, yes. But the Jacob in this black and white, these complaints that have been coming over in my computer on my bench for the last few years, that is not the Jacob you are. And you should not want to be that Jacob. I want to see you do better, and I want to see you succeed, and I know you can succeed. Get back to your roots. Do you do any tribal activities?
Not since I was in school.
Why not?
Well, because they don't really have any activities unless I actually work on the reservation.
Can't you get into the drumming? Can't you get into the powwows? Yes, you can. You can do those things. Those things will reconnect you. They will, Jacob. Take control. Do those things. Because you need to be, you're an uncle. You need to be a good example. Why are you smiling?
Because I'm about to have a kid in September. So, yeah.
I feel like Home Alone. I don't even know what to say. I'm happy for you, but if you don't start turning things around, Jacob, I've always spoke blunt to you, and I always spoke blunt to your father. I speak blunt to your mother. I speak blunt to your sister. Knock it off. I don't want to see you ever go to prison, and I don't want to see you in that chair anymore. Get back to your roots, because you're going to need to show your son or your daughter who they are. Right?
Right.
Because we're all losing that. Don't lose that. So the happy thing, but now it's time to grow up. Right?
Right.
Probation is appropriate, and so I will follow the recommendation as to 1 year of probation. What I am going to do is I'm not doing a withheld sentence. You're going to know the punishment if you're not going to man up and you're not going to start to take control of your life. I don't know a jail credit. What's the jail credit? Have you calculated it? I know we sat some time, not a significant amount, maybe a week here, a week there, those kinds of things.
Sat this summer and then a week.
A couple weeks or something.
Yeah.
I don't have the credit, Your Honor. I'll have to get that.
What I'm going to do is I'm sending you a message, but it's not a harsh message, but it is a message. Okay. Because if you're revoked, don't want to see you revoked, 6 months in jail.
Okay.
Okay. 6 months. A long time, Jacob.
I know.
So do better, be better, change your habits, change your associates, the people you hang out with, change the things you do. I want you to be able to be a grandpa in however many years and have your little grandchildren sitting on your lap so you can tell them stories of your ancestors, okay? And to do that with your child as well. So 6 months imposed, but stayed. So if you're revoked, you're going to sit 6 months. It's a long time. Mr. Davis, you have 1 week to get me jail credit so that we can amend the JOC if we need to. While on probation, no alcohol, absolute sobriety, no use of or possession of any illegal drugs, substances, or paraphernalia. I'm going to say regular testing of alcohol and or any illegal substances. An AODA, an alcohol and other drug assessment, and follow through. Okay, so you have to do all of the follow through. I'm ordering that you get your driver's license. You have to get your driver's license. You need it, you want it, and I want you to get it. No abusive contact with, I'm putting it out there with your sister, with Ashley Oyat. No, what about AMD?
I'll let Kevin decide.
Our computers are very slow as well today.
You know if AMD wants to have any contact?
I'm reading her info
Do?
right now.
No abusive contact with AMD. Got it?
Got it.
Jacob, do better, be better. Okay? And then when you're doing better and you're being better and you have that little baby, you bring me a picture, or better yet, you bring that little baby in here so I can see him or her. Okay? You have 20 days to appeal. If you fail to appeal within 20 days, you lose that right. $500 I'm assessing for fines, fees, and all of the things, plus an additional $100 DNA surcharge. Any additional bail that's been paid will be remitted back to whoever posted it, if it was you or whomever posted it for you, okay? I need your DNA. You're gonna need to go to the jail to make sure that they have it. If they do, they'll take it. If they need it, they'll take it. If they don't, they'll send you on your way. With this, with the domestic abuse modifier, I do not believe you can have it expunged from the system, but you can attempt to, you can try through a written letter to the Department of Justice, not to me. We're gonna get jail credit, fail to pay, oh, you already are gonna pay with the bail. I think that covers everything. Mr. Schmidt.
Nothing from me.
Report to probation.
Thank you.
Can you get, I don't know what time they close.
3:30, they close at 4 or 4:30. I'm gonna say by 4 o'clock tomorrow, make sure that you go to probation, you get it all set up. Are you still on Sandpoint Road?
Yes.
Telephone ends in 3461.
3461.
Do you have an updated?
No.
If you have a number and you can think of it after, make sure you tell the clerk's office. But I'm required, I tell probation that I'm gonna make sure I get your address, have your telephone number, all of those things, okay? Very important. I would go to probation today and do that instead of waiting until tomorrow.
That's my plan.
Okay, so do that first. Worry about the DNA tomorrow or another day, okay?
I can do that until up to 4 tomorrow for the DNA.
Yes, yep, okay. All right, anything else? Okay, yes, Mr. Boyan.
Where would I go for that? Around the back to the
All the
jail?
way to the back to day reporting, okay? So come get your information, go to the probation, get that done, then worry about DNA. I think they can even take DNA at night. I'm not sure.
You ready to report about? I'm ready, yes. Okay, case number 25S01276SM, People State, Michigan versus Maria Porter Bonner. Good morning, Your Honor. Courtney Rose on behalf of people. Okay.
Good morning, Judge Johnson, Jacob Schwartzberg, P 37693, on behalf of the Porter Bonner.
Okay, Ms. Schwartzberg, good morning.
Can you please tell the judge your name?
Yes, my name is Maria Suzette Porter Bonner. All right, Ms. Porter Bonner, you are here for one count of domestic violence. Today's date scheduled for trial. People prepared to proceed?
Yeah, we're not prepared to proceed, but I have some concerns that I'd like to place on the record.
Okay.
The incident that was alleged involved Ms. Porter Bonner's grandchild, who was, as I understand it, the daughter of her son. Her son has custody of the grandchild, the victim. I did reach directly out to the victim. I think she's either 15 or 16, and I spoke with her, and we had a decent conversation. I then reached out to her father once I got her father's contact information, which I previously didn't have. And I was, in short, I think this just came short of threat by her father to leave the victim alone, that she would not be attending court to testify against his mother, and that he actually threatened to call the police on me. I'm concerned that this lack of acceptance of the situation or respect for the situation where the police were involved for alleged abuse on a teenager is being disregarded to the point to where an adult caretaker of the child is coming short of threatening the prosecutor to not talk with his child anymore, his teenage child. I understand that there's an ongoing case with CPS in Wayne County. I've reached out to the person who I understand has the case file. I've reached out to that person, I think 4 times, and I haven't gotten a call back. You're talking about the CPS worker. Okay. I'm concerned for the state of this family. It sounds like there was abuse, at least from the allegations, not just by Ms. Porter Bonner, but potentially also by this child's parents. I just wanted to place all of that on the record and note that I'm not surprised that my teenage victim is not here today, given the conversation I had with her custodial parent.
I am not aware of anything that the prosecutor has stated to the court. I am aware that this incident, the granddaughter was believed to want to commit suicide, and the granddaughter was living with her grandmother, Ms. Porter Bonner.
Yes.
At some point,
That's fine.
the granddaughter's mother came to the location. There was a dispute. At some point, Ms. Porter Bonner was arrested. I think that was a little heavy-handed part of the officers at the scene. However, you should know that the granddaughter was taken for a mental health hearing after this incident.
Yeah.
Now, what happened after that, I don't know. The granddaughter was living with her grandmother, Ms. Porter Bonner, for about a year.
And now she's not back there anymore.
No, she's not there anymore. I don't know what type of after mental care
Yes, no.
is being offered to granddaughter, unless Ms. Porter Bonner, do you have anything you want to say?
Yes, I do have something I would like to say. My granddaughter, excuse me, good morning.
Come on.
My granddaughter has stayed with me on and off, not because she had to, because our bond is so close. Plus, her school is closer to me. My son stated to me that the prosecutor and other people has called my granddaughter night and day, day and night. And by the time they've spoken to him, she threatened, he said that she did not want to testify because initially this thing came about with her mother not calling because there was some abuse. Her mother called to get her daughter mental health services. My granddaughter, all her life, she's been a great kid. She had an abortion a few weeks prior to this incident, and her emotions was just every which way. She was threatening, just acting in a way that she's never acted with any of us ever before. And it was shocking. And I'm trying to get ready for a Christmas party for the youth in our church.
You don't have to get into.
Just hold on 1 second.
Now let her speak. I'm here to listen.
We're trying to get together for a Christmas party where we would do it annually. It's like a pajama Christmas party for our youth department, which I work and been working in since I was in my 20s. I'm like 60 now. And she just snapped out, screaming and hollering, and and so her mother came because her mother was on the phone and she heard it. And she came over to deal with her. At this point, I'm like, you know what? I got over 100 kids waiting on me, and I'm gonna let her mama deal with her. At some point, she had a butter knife saying, I'm gonna hurt myself, I'm gonna kill myself. And it scared her mom. Her mother called the police thinking that they're gonna send an ambulance to help her, to take her to get mental health. And the next thing I know, I'm in handcuffs. I went to jail. I've never hit, harmed, abused no children in my life. I have 7 twins and will be 40 years old this year. Jamie's father is my youngest child, 37. And again, he called me and said that the prosecutor threatened, well, if she doesn't show up, then I'm gonna have her picked up and he said to me, I was not there, but this is what my son said to me a couple of days ago. He said, what he said to her was, if you had anybody go near or take my minor child, I will go to the police department and press charges and tell them that you had her kidnapped. When I have told you, when she has said she never wanted to press no charges against me, this is a child that have her big butt in a bed with me. She don't have to sleep in the bed with me, but this is what she chooses to do. I cannot go anywhere. This is my best friend. She can tell you herself. She's been around her entire since she was born. There is no abuse. And I told my son when he told me how he spoke to you. And just because I know they're grown, but I'm still their mother. And just because he is my child, that doesn't give him a pass to be anything other than what he was raised to be. He had no business. I know that you're upset. This is new to all of us. We don't have police involvement in no areas of our lives. My son gets up and goes to work. All of my children do. They have their own homes, their own families. I sleep really well at night. Don't have to worry about nobody, Your Honor. Nobody. My husband died in 2023. A husband who took care of me. He took care good to us. My baby boy. First person on that phone. Mama, how much are those bills? In my mind, okay, I'm gonna just have to go back to work. Mama, you can't do the things you used to. And even if I have to do it by myself until Social Security, disability, all that kicks in, we got you. I don't have sons or a daughter that they don't do drugs. They've never been no street kids. My daughter had a baby early. My oldest grandson will be 25 this year. Good kid. And my daughter took care of him. And all the rest of them, they don't live in Philly. No, but CPS people came out to my house and the supervisors came, they called. In all my years, I've never had a CPS interview, conversation in my entire life. And those ladies told me, and can I find the letter? I was hoping that she sent it to you. She said, this seems to, we don't have no case here. It sounds like your granddaughter was disciplined and told me that the next time that she acts this way or that way or whatever, gave me things that I can do in terms of either diffusing the situation or just me protecting my, not just my physical health, but my mental health. My granddaughter is 5'9". She outweighs me almost 50 pounds. It would be pretty hard for me to abuse her. Like I said, I was in a car accident. The majority of my neck is screws and a rod. I have arthritis everywhere. As bad as I would love to get up and go back to work and to be as a caregiver, as a paramedic in healthcare, what I've been doing since I was in my 20s, I can't do it anymore. Young man T-boned me on Outer Drive on Mother's Day when I should have been at church, but I'm picking up a grandchild, take him to the airport. He T-boned me and broke my neck. It destroyed all the cartilage from my bra line to my tailbone. I'm all bone on bone. It fractured my hip in 3 places, plus rotated it. I can't fight nobody. And it would never be my intention again. I teach kids the word of God. And I've been outside of the church. I'm still trying to help them to develop to be productive, good human beings. What the heck, all of a sudden, at almost 60, I'm just gonna up and decide to abuse somebody? No, I didn't. I did not, and this is why I wanted to have a bench trial. I said I refuse to take a plea. I don't need no jury trial. I didn't do nothing to hurt nobody. I did not. I had a granddaughter who problems, she slipped up. She did. Ain't no two ways of looking at it, but I'll still say that for the most part, she's a wonderful kid. She had a moment in her young life. And she's still trying to understand the way her body works. My mother was a registered nurse. Ended up being a nurse practitioner. Right. 2 sisters, nurses, and one a pharmacist. Yes. They could talk to me all day long when I was 15. I still felt like I knew better than them. Or I already knew, or y'all take too long telling me something. I got a phone call to make. I got to go to movies down the street. She's a kid. I don't have no intentions on throwing her away. I want her, as well as the other 12, 13 plus bonus grandchildren, to have the benefit of me, like I have with my 2 grandmothers. I wouldn't let her back in my house. She's a child. And she needs guidance, she needs understanding. We all have to remember that none of us was born adults. We were all babies. They're not adolescents, teenagers, young adults. She has to go she's on her path. And I miss
Well,
in my life. And she's been born. I didn't get to see her for Christmas. Thanksgiving, New Year's. She the main one that has the cuts and checks. And my house, thank you, I have a 2-bedroom apartment. She don't care as well as the rest of them. She tell me later, oh, Grandma, I meant to tell you. We have to sleep off at your home. When? Friday night. And it's okay, because I'm just thrilled that grandkids, plus they friends, and some of them have sisters and brothers that's not related to me, they still want to hang out with me. A lot of kids don't want to be back with their grandparents. They don't want to be back with their parents, let alone I can't get rid of them. You see this? I got air mattresses They're not air mattresses, they're air beds. I got fallout full times. They stay in my house, two girls is in the bed with me. I put them out, they come in. Even Jamie did, but she has a room. Jamie, every night they got the same routine. She got to put on all her jewelry, wrap her hair, put her face cream up, get in the bed with me. So, Grandma, did I tell you about such and such, such, such? We are very close. Her mom, my son is fully married to someone else, been married. Got an autistic child with this lady. But I've known Jamie's mother since she was 14, 15 years old. She married and divorced, had other children. I found out she was sleeping in her car. Come on, stay with me. I don't need no money. I just want you to work, continue school, save your money, get somewhere decent and stay for your babies. I'm not a messy person, of course, because my first responsibility is to my legal daughter-in-law, Asia. How do you feel? I don't want you to think well, I understand. I'm okay. It's okay. I know what she's going through. Told my son, she's still your family by default because you got a child. If you can help her, you help her. So in terms of you having a concern about our family, we are a Black family. And our way of discipline, it might not be something that you agree to, but like my ex-daughter-in-law said, yeah, she whooped her daughter. She did for disrespecting her grandmother and told the police, yeah, I whooped her, and that's not illegal. She took a belt, she tried to do the best she can. She even smaller than me. But nobody abused Jamie. Jamie had an outburst, and it has snowballed into leading me up into handcuffs. And that is just not the family that we are.
Your Honor, if I may, Michigan law is the same for African-American families or white families or people of any race, anybody in Michigan. There's a defense to domestic violence or to assaultive charges described as parental discipline. It's noted in Michigan Criminal Jury Instruction 17.24. That jury instruction states that it is not a crime to discipline a child. A parent or guardian or other person allowed by law or authorized by the parent or guardian may use force to discipline a child, but this does not mean that any amount of force may be used. The law permits only such force as is reasonable. And that is going to be the central issue for the trial here today, whether or not what was alleged by the victim to the police was reasonable. And so I'll just state my concerns again, that it sounds like there are a lot of children in the home. Sounds like defendant is trying and in some cases doing a very good job, but there is a line, and that line is what is reasonable as far as what can be unlawful or what can be considered discipline. I'll note that I called and spoke with the victim once. I'm sure the Southfield Police Detective Jadovich reached out to her once. I don't believe she was contacted more than that. And that the other statements by a defendant regarding her son are pretty much correct. I discussed with him subpoena power and how it's not an option or an invitation to come to court, but that it's mandatory. And I also discussed the availability of the option to seek out a material witness warrant. So that is what our phone call was about. Obviously, I have no witness here today, so I can't proceed. I'm sure Mr. Schwartzberg has a motion to make. I just hope that we don't see Ms. Porter Bonner or the child's mother in the courtroom again one day in the future, because that line for discipline, whether or not it was reasonable, was blurred.
Okay. Well, I feel what you're saying, Ms. Porter Bonner. And I'm from an African-American household, obviously, because I'm African-American. And I'm old enough to know that kind of discipline, switch off the tree, an extension cord, all of those things they used to do way back before you were born. You can't do that like that anymore. I'm not saying you did. I'm just saying nobody can anymore, but they can still discipline. And I don't even know what this case would have been about. I was waiting to hear. But if it was as to what was done, not whether it was done, but what was done and was it reasonable, then that would have been the question up for trial today. Because discipline is okay. You can still do corporal punishment, but the question is, were the methods for corporal punishment reasonable under the circumstances? And that would have been a good question. I understand what you said your granddaughter is going through. She got growing pains. She did go through a traumatic experience with the pregnancy that she terminated. I'm aware that sometimes the police are not the best people to call when there is a mental health breakdown. Most of them aren't really trained in that. And that's how you hear stories about, hey, this person was deemed to be bipolar or autistic, nonverbal, whatever, and they end up getting shot and killed. Because officers come, they don't know. They think something's gonna happen. They think that they're, in a position where they're gonna be injured and the person gets killed. So I know you call the police, you don't necessarily get that result if they're gonna take them to the hospital. Not really it. So I would suggest that she's going through something that, and if CPS has dismissed your matter, which it sounds like they did, that you seek out professional care for her.
She's getting it twice at school and outpatient. I don't remember the name of.
Yeah, because if she's talking about trying to kill us, that's something deep, and you cannot overlook that because she will do it. These younger people are doing this, and it's not to be taken lightly. And you don't know what's going on deep inside of her on top of the things that you have identified. So you definitely gonna have to stay, you gotta watch her, you gotta stay on top of her. You gotta understand her that she's, I don't know. Young people these days have a whole lot more pressure and issues. I didn't have any problem. I didn't think, there's too much nothing going on back in my day. But nowadays it's different. You got bullying, cyberbullying. There's always been bullying, but it's a whole new level of things out there now that really get to kids' mentalities. And it just goes across all races. I remember someone talking about a young man that went to University of Detroit High School that took his life just a few years ago. Same kind of situation. Suffering, bullying, gone. So you got to take that seriously. You got to stay on top of her. Whether she's here today because she doesn't want to be or not, she's not here. And your lawyer will be making a motion, I'm sure, momentarily about that. But the question is, where do you go from here as a family unit so that you don't get charged with anything like this again?
She can live with me.
Yeah.
And like she can visit, she can spend the night, she can participate in all the
Things happen even on a visit. Things can happen on a visit. Things can happen on an overnight. So you just have to take those precautions. I understand not living with you, but you can't let your guard down thinking that just a visit and an overnight, it's going to be okay, because it might not be. It might not be. So you got to, you and her mother and your son have got to stay on top of that for her.
And like I told,
because from what I'm hearing, I don't know how this whole thing, came to pass the way it did with the police and you getting charged. And I don't know what happened, because I still don't know. I've never been told anything about it. But I do know prosecutors do their job, and it is their job to call people and talk to their witnesses and things like that. So, I'm not sure what happened with your son and why he was as hostile as he was, but hey, they're doing their job on their side of things, because there are circumstances where people would be upset if they didn't do their job under similar or even worse circumstances. So, they got to do what they got to do. And this might have worked out to your benefit because now you don't have to try this matter. You're presumed innocent up until the time that the trier fact goes to deliberate and make the determination that you are guilty or not. So you're presumed innocent. Yes, you going through some mental stress with this whole thing, but it's a learning experience. It's a learning experience. And so take what you've learned here to put some things in place with the family unit where you all can deal with that small crisis that the young lady might be going through that caused this whole thing to come about the way that it did. And I'm going to certainly wish you good luck and Godspeed on that. What do you want to say, Mr. Shorts?
Yeah, and I'd like to dismiss this case.
All right. So I'm going to go ahead, Ms. Porter, and dismiss the case.
Yeah.
It'll be a dismiss because the prosecutor cannot proceed. They don't have a witness. That makes it a dismissal, what we call without prejudice, meaning that if they wanted to, they could rewrite the case again if they got a hold of the witness. That's in the prosecutor's discretion, whether that happens or not. Sometimes it does, a lot of times it doesn't. So just be advised, it's gone for now, could come back if they choose to do that, which they may not do. And that gives you an opportunity to kind of breathe a little and go ahead and try to address these issues, because I hate to hear that your family is in a little bit of turmoil regarding this. But I think it sounds like you got your head on straight and you're doing some things right to try to address the situation. And the fact that she's in therapy has got to be one of those big components that you're going to have to do. I don't know if anybody hit anybody. I don't know what the case is about, like I said, but just know what the prosecutor said. That was a right recitation of the law. You can, use corporal punishment. It's just a question of what is reasonable. And so sometimes when we're thinking about it, most of us say, well, I turned out all right. Well, yeah, you did. But your parents might get arrested if they tried that now. So just keep that in mind. Okay. So the case is dismissed. The bond is canceled. You don't have any monetary bond, so there's no money to refund to you. And this was at a bench trial. So you're all set. Good luck.
Is there an order that we'll get?
No, but if you want one, I can write one.
Thank you.
You want one?
Yes, please.
Okay, here's an actual written order. And you're all set. All right. Oh, there it is.
Okay, the court is on the record in City of Conneaut versus John M. Good. Case numbers 26 CRB 8, 25 CRB 238, and 25 CRB 161, and 23 CRB 180. In 26 CRB 8, Mr. Good pled not guilty to 5 charges using weapons while intoxicated, 2 counts of aggravated menacing. All 3 of those charges are first-degree misdemeanors, and 2 counts of domestic violence, each of which is a 4th-degree misdemeanor. Those pleas were entered on January 12th, 2026. We conducted a first pretrial conference on January 26th, and today this case is set for a second pretrial conference. In 25 CRB 238, Mr. Good has a probation violation case or complaint that's been filed against him on December 16th, 2025. He entered a not guilty plea on January 26, 2026 at a preliminary revocation hearing. This case is set for a final revocation hearing. In 25 CRB 161, a probation violation complaint against Mr. Good was also filed on December 16th, 2025, although that complaint does not mirror the complaint filed against him in the previous case. The allegations contain different allegations. Again, Mr. Good pled not guilty to that complaint, and this case is set as well for a final revocation hearing today. The last case, 23 CRB 180. I believe this case is simply a payment issue. There's no probation violation complaint pending in that case yet. Mr. Good is present. He is accompanied by his attorney, Matthew Schultz. Also present is Law Director John Lewis and Probation Officer Sean Benoit. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. With regard to the 26 CRB 8 case, the offer that's been extended to Mr. Good would be to plead as charged to using the weapons while intoxicated offense. With that plea, the city would dismiss the aggravated menacing counts at defendant's cost. The city would also amend the domestic violence counts to aggravated disorderly conduct under 509.03 B1 E3A. The city would recommend probation, fines, and court cuffs. Prior to going on the record, Your Honor, I spoke with both Jason Rout and his father, Dennis Rout, who is the father and grandfather of the defendant. And they were in agreement with this proposed resolution of the pending matter. And they are not seeking a post-conviction no contact order. With regard to the two probation violation cases, the offer that was extended to Mr. Good would be to admit both of the violations, and with that, the city would recommend a 5-day term of incarceration. Thank you.
Thank you. Mr. Schultz?
Your Honor, after speaking with Mr. Good, we were going to go ahead and accept the offer from the city for the 26 CRB 8 case, as well as we will be pleading to both violations today, pleading guilty.
Thank you. We'll start with Dennis Rott. Mr. Rott, did you understand the proposal that Mr. Lewis just explained on the record?
Yes, Your Honor.
Okay, are you in favor of that proposed resolution?
Yes, Your Honor.
Okay, are there any questions you have regarding the proposal?
No, Your Honor.
Okay, thank you. And Jason Rott, Mr. Rott, did you understand the proposal explained by Mr. Lewis?
Mm-hmm.
Yes?
Yes.
Okay, do you, are you in favor of that proposed
Yes.
resolution? And do you have any questions about it?
No.
Okay, thank you very much. Okay, Mr. Good, it's my understanding today, based on what has just been represented, is that you would enter a guilty plea in the 26 CRB 8 case. You would change your not guilty plea and enter a guilty plea to one count of using weapons while intoxicated, a first-degree misdemeanor, and to two amended counts, amended from domestic violence, fourth-degree misdemeanors, to aggravated disorderly conduct. Each of those would also be fourth-degree misdemeanors. In exchange for those guilty pleas, the two counts of aggravated menacing, first-degree misdemeanors, would be dismissed at your cost. Also, you would be admitting to the probation violation complaints filed against you in 25 CRB 238 and 25 CRB 161. Is that what you would like to see happen today?
Yes, Your Honor.
You understand by pleading guilty to the charges and to admitting to the probation violation complaints that you would be waiving your right to a trial in the new case, as well as to a final revocation hearing in the probation cases, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. In the new case, you'd be waiving your right to be proven guilty beyond a reasonable doubt. And in the probation cases, you'd be waiving your right to be proven guilty by a preponderance of the evidence. In the new case, you'd also be waiving your right to a jury trial. All of those are trial and hearing rights you'd be waiving by pleading guilty and admitting to the complaints today. Is that what you wish to do?
Yes, Your Honor.
You are represented by Mr. Schultz. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, Your Honor.
Are you outside of this court? Are you currently on probation, parole, community control, or post-release control with any other court?
No.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to these charges today?
No, Your Honor.
And are you thinking clearly and do you understand everything that's happening? Okay, I'm going to provide to you and to Mr. Schultz 3 waivers. One is a waiver of your trial rights and right to a jury trial and acknowledgement of effective plea in the new case. And the other are 2 of your waiver of hearing rights in the probation cases. Okay, the court does find Mr. Good and Mr. Schultz have executed in open court the written waivers in all 3 cases. The court does find the proposed resolution acceptable. I do find that the defendant's pleas of guilty to charges of using weapons while intoxicated, a first-degree misdemeanor, and 2 counts of aggravated disorderly conduct, a 4th-degree misdemeanor, under Section 509.03B1E3A of the Conneaut City Ordinances, as well as his pleas of guilty to the probation violation complaints filed against him to be known, finding guilty of violating his probation. Okay, we'll now proceed to sentencing. Mr. Schultz, is there anything you would like to say before I impose sentence?
Yes, Your Honor. First, Mr. Good did inform me that he has recently started working with a case worker for community counseling, setting up and going to appointments. Has about 1 weekly, I believe, or what was it, 1 to 3 weekly? 1 weekly. Okay. And he's gone to 3 so far just for mental health and drug treatment. He's not trying to make any excuses for the 10 hours community service failing to do that for that 25 CRB 32 case violation. When it comes to the part where he failed to find a job, he did let me know that he has reached out to over 60 jobs and he's not getting calls back, nor does he have interviews set up, but he has let me know that he has made efforts in finding a job. For the drug test, for the marijuana, he admits that he fails the drug test, doesn't contest that. He did tell me that he's been sober since he was released from jail, so it could be that it just stays in the system for 30 days and he's still failing. He did tell me that he would probably not pass today if we were to take a drug test. And then that's all I wanted to mention. Thank you, Your Honor.
What would he fail for? What do you mean? What types of drugs?
Just marijuana, because it's just still in his system.
Okay.
And I also forgot to add my apologies that he has been continuing doing his GED classes. Thank you.
Thank you. Okay, Mr. Good, is there anything you would like to say at this time before I impose sentence?
No, Your Honor.
Okay, Mr. Lewis.
Thank you, Your Honor. With regard to the 26 CRB 8 case, officers were dispatched. This was January 8th of 2026. Officers were dispatched to 300 Cleveland Court. The caller, Dennis Rout, advised that John Good was in possession of a firearm and threatening to shoot family members. Once the officers arrived, Mr. Good had fled on foot, and that it was known that they didn't know which direction he went, but both the alleged victims here advised that Mr. Good had the firearm on his person. Officers interviewed the father and grandfather, John and Jason and Dennis. Rout indicated that John Good was arguing with them. He was intoxicated, falling into household items. Dennis Rao, told John to sit down so he didn't, fall and hurt himself. He became angry and told Dennis that he would knock him the F out. Argument continued, and at which point, Good threatened to, shoot, Dennis Rao, advising him, "I will pop your ass, old man." Meaning he would shoot him. Also, there was an argument with his father, Jason. He also advised him, threatened to beat him up, and also advised that he would, quote, pop his ass too. I would note that that Mr. Good did not have the firearm on his person while these threats were made, Your Honor. He picked up the gun as he was leaving the house on foot. Both his father and grandfather advised the officers that he had drank or consumed a bottle of Mad Dog 2020 wine. And Mr. Good admitted to the officers when they did find him, that he was found with the firearm on his person, and he also advised the officers that he had consumed the Mad Dog wine. Thank you.
Thank you.
Community Councilman Center this morning for update on his treatment. Haven't had a response, Your Honor. The only update that I have received that I can confirm is that he has been attending his GED classes, completing 5 classes thus far.
Okay, Dennis Rod, is there anything you would like to say at this time before I impose sentence?
No, Your Honor.
Thank you. Jason Rod, is there anything you would like to say at this time before I impose sentence?
No, Your Honor.
Okay, thank you. Look, Mr. Good, I'm not messing around with you anymore. Okay?
Sir.
You've been before me, been on probation, you keep not doing what you're supposed to be doing. And then this happens. And now all of a sudden you have a revelation and you're going to treatment, which is what the hell I've been telling you to do. I'm not messing with you anymore. You are going to jail. You're going to jail. Just not today. Because we have no room.
Yes, sir.
I tried to devise a plan for you in these other cases, these older cases, a plan where you could get your life in order, ordering you to get your GED, ordering you to get a job so you could support in some way financially your household, ordering you to get treatment that you desperately need. We devised this plan to help you. And it's not like this is the first time. We've had sentence compliance hearings. We've had previous probation violation cases. What is going on? And who are you to threaten your dad and your grandfather with a gun? On older cases where a gun was involved. Who do you think you are to threaten family members with a gun? Young man, let me just tell you, after you serve the jail sentence I'm about to impose on you, if you screw up one more time before me, and this probation officer seeks to violate your probation, I don't care. you're going to get the maximum sentence, and I'm throwing away the key.
Yes, Your Honor.
I don't get it. When this court bends over backwards with people to try to help them get their lives back together, and they just simply refuse. They refuse the help. It's excuse after excuse after excuse after excuse.
I'm done with excuses.
Yeah, I am too. He spent 8 days in jail from January 8th to January 16th, 2026. Is there any objection to 8-day jail credit?
No, Your Honor.
No, Your Honor.
And those are only on yeah, those would be only on the new case, right? He didn't.
I agree, Your Honor.
Yeah. Yeah. Excuse me. In 26 CRB 8, I'm sentencing first on the using weapons while intoxicated, that being subcase A. 180 days in jail. 172 will be suspended. I'm giving him the 8 days jail credit. I'm placing him on supervised probation for 3 years. He's to have no criminal offense for 3 years. $150 fine and court costs. I'm going to give him an opportunity to perform community work service to pay his fines and costs off. She needs to start doing it immediately, not just on this case, but in all cases. He's at Ravenwood, right?
Yes, Your Honor.
I'm ordering that he successfully continue his treatment at Ravenwood. I don't want to hear one bad thing about your treatment. I don't want to hear one missed appointment. I don't want to hear anything that you refuse whatever they're recommending. You're going to do everything they tell you. You got it?
Yes, Your Honor.
You're to successfully comply with the recommended course of treatment and execute any necessary releases for our probation department to monitor. You're ordered not to purchase, possess, or consume any alcoholic beverage, drug of abuse, or any pseudoephedrine product, or go into any bar or liquor establishment for a period of 3 years. I am ordering you, as a condition of your sentence as well, you are not to possess, you're not to own, you're not to purchase, you're not to be in the custody of any firearm or ammunition while you are on probation. It goes without saying, but I'm making a specific condition, so it's clearly marked in the sentencing record. When I say it goes without saying, because that's a typical standard probation condition. One second. This sentence will run consecutive to all of the sentences. Actually, all of these sentences are going to run consecutive to all those sentences. On the subcase D charge of aggravated disorderly conduct, 30 days jail, 22 days suspended, 8 days jail credit, as I previously said, 3 years supervised community control, $150 fine and costs, permitted to perform community work service in lieu of fines and costs, successfully continues treatment at Ravenwood. Not to purchase, possess, or consume any alcoholic beverage or drug abuse in a pseudo-friendly product going to a bar or liquor establishment for a period of 3 years. Not to possess, own, purchase, or be in custody of any firearm or ammunition during his probationary period. Consecutive other sentences. And the same goes with subcase E. Same exact sentence, 30 days jail, 22 suspended, 8 days jail credit, 3 years supervised community control, $150 fine. Ravenwood successfully complied with treatment there, not to stay drug and alcohol free as previously ordered. And just to make clear on the record, Dennis Rott and Jason Rott, are you asking the court to order John Good to have no contact with you?
No, Your Honor. No, Your Honor.
Okay, thank you very much. Now on the probation cases. I'm extending the defendant's probation in each of these cases for 1 year. In 25 CRB 238, where he has 90 days of jail that are suspended, I'm imposing a 10-day jail sentence. 80 days will be suspended. He's ordered to all of the same conditions. He's ordered to stay drug and alcohol free as I previously ordered in this case. He's ordered to, actually, I'm not going to modify anything that I previously ordered. Again, he's ordered in this case not to own, possess, or be in control of any companion animal. Stay drug and alcohol free, continuous treatment at Community Counseling Center, which is now Ravenwood. And that sentence will be served, will give him a jail report date. And then in 25 CRB 161, where there are 179 days of jail, I'm imposing a 5-day actual jail sentence. I will suspend the balance, or the 174 days. And that will run in addition to the 10 days in the other case. Now, in this case, I ordered him to obtain his GED and obtain and maintain employment. I'm continuing that previous condition. I'm also I want to see where he's at in 90 days, so I'm going to set all of these cases for a sentence compliance hearing in 90 days. I'm also adding a condition in this case, because this is a firearm case as well, that he not be in possession of, custody of, control of, and own, purchase, or possess any firearm or ammunition. I'm also going to continue the order that he obtain and maintain employment. And I'm adding to this condition, if I hadn't already done it as part of a probation violation, that he continue successfully his treatment at Ravenwood Health. and that he remain drug and alcohol free. So he's going to have to serve 15 days in jail, which we will give jail report dates. Mr. Good, you have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have the right to have documents provided to you necessary to file an appeal without cost. You have a right to have a notice of appeal timely filed in your behalf. Is there anything further, Mr. Lewis?
No, Your Honor, thank you.
Mr. Schultz?
No, Your Honor.
Officer Benoit?
No, Your Honor, thank you.
Dennis Rod, do you have any questions about what happened?
Your Honor, I was just wondering if you would be able to come to the house again.
I have not prohibited him from having any contact with you, so he's free to have contact with you.
Thank you, Your Honor.
You're welcome. Jason Rod, is there anything you would like, any questions about?
No.
Okay. Okay. Okay, these matters are concluded. Thank you.
How's the ankle monitor gonna work? Is it, you can talk outside, or?
Hamilton Crossing 2 versus Tierra Pratt.
Jillian Engen for plaintiff.
Is Pratt here?
I'm here.
Okay, there she is. Hello.
Hi.
Okay, what is the claim in this case?
I have two things, Your Honor. Rent plus court costs totals $4,033. Your Honor, we also have a conditional order of dismissal from a previous case that is still applicable. And so I think that we might be filing an affidavit of noncompliance under the conditional order of dismissal for the previous case.
Nope.
Got it.
That's incorrect, and I will be contacting the lawyer. The COD was paid off in December, and also they were charging me late fees, and I for each month, and I already then on the account I just made a $2,600 payment, $2,684 payment yesterday, and that should be on the account. And she said that she was going to remove the late fees, and they So
hold on, Miss Pratt. You paid how much yesterday, you said?
$2,684 yesterday.
Yesterday.
Mm-hmm. And also the COD was paid off in December, and they kept applying late fees on this on my CD each month. So I have not been in compliance. The COD was paid off in December. So what you're seeing
Okay.
on there is
Okay, Miss Pratt?
Your Honor.
yes.
Okay, right now, I don't see any of that, right? 'Cause
Well,
I
she
just
should
have
be
this
able
in
to
front of
see
me.
it.
Okay, ma'am, hold on a moment. Here's what I'm gonna do. I'm gonna
So-
adjourn this to March 13th, 2026, 1 PM. Bring all your that's an in-person hearing. Bring all your documentation and everything. By that time, your payment should have caught up. Your March rent will click in. But then if they file the affidavit, I can also take a look at that case and make
Okay.
a determination as to what's happened on it,
And
okay?
then I shouldn't even have no legal fees because I just talked to the manager yesterday, and she told me that they were gonna dismiss this, but I showed up just in case because I knew it was gonna be some drama. And I'll have my lawyer reach out to them.
Well, there's no drama yet. I'm just,
Well, it's
everybody's just
like
telling
they
me
just
their
not doing
thing.
what they supposed to do, and then have
Well,
me with
ma'am,
court
Miss
fees.
Pratt, I've listened to you. I told you there's nothing I can do right now because I don't have all of that in front of me.
Okay.
All right? So I've set it out 2 weeks at 1 o'clock. You say you're gonna get an attorney. Let them know when that is.
Okay.
And then everybody will be here. The account should be at least reconciled. I can take a look at everything and tell you where it is. But you're just talking at me right now. I can't do anything about it.
I know. Thank you. So you said,
Thank
and
you.
when is it? So I can be clear, because I was over
March
talking you and I apologize.
13th. March 13th, 1 o'clock.
Is that in person or is that
That's
Zoom?
in person.
Thank you.
Okay, and if I can't do in person?
Well, you can file the Zoom request, but I don't know how you're gonna get the documents and everything to me. So I'm setting it in person. You can file the Zoom request, but it may not be granted.
Okay, I'll try to get the day off.
Thank you.
You're welcome.
Hamilton Crossing 2 versus Coyote, is it Ayodele?
Yes, I'm here, Your Honor.
Okay. And also the other Ayodele. I'm not even gonna try that first name. All
That's my
right,
wife.
sir.
I do. That's my.
All right. Okay. What is the plaintiff's claim?
Jillian Ingham, if Your Honor, the balance that I currently have is $3,228 in costs, but my client is looking at the rent being assessed. I just a brief overview of the issue, whether or not rent can be increased if there's an income change for I think I'm sorry, Isha's here, so she can correct me if I'm wrong. She's the property manager. But there's a question as to whether rent can be adjusted in the interim during a lease period when tenants' income changes. And so we're going to be looking at this and getting her an answer so she can get a final number for the rent. And so, Your Honor, we're just relating to adjourn this. Like, is what
Okay. And I should say, is it under Anke?
I do.
Ma'am, help me with it. Give me your name. I see you up there.
It's
Got it. Okay.
I prefer
So,
Adi.
all right. What I'm going to do is I'm going to adjourn this out to the 13th of March. They're going to be taking a look at your account, and then we'll figure out where we'll go from there on this. Okay, folks?
You said that March 13, right? What time?
Yes, it'll be March 13th, 2026 at 1 p.m. That's in person here at the courthouse.
Okay. Thank you.
Okay, they'll get your account reconciled, look at what they're going to do, and then we'll have a number, and then we'll figure out how we're going to work this through. Okay?
Okay, thank you.
Thank you, Your Honor.
All right, thank you. You guys have a great weekend.
Have a good weekend too.
Hamilton Crossing 2 versus Jessica Jackson.
Jillian in for plaintiff.
Oh, there she is. Miss Jackson's here. She's just trying to figure out how to unmute. All right. Hello, Miss Jackson.
Hello.
All right. How much is owing on this?
Your Honor, I have a balance including court costs of $1,440.
All right, Miss Jackson.
Yes,
How
sir.
are we going to get this? How are we going to get this paid?
Couple weeks.
Okay. You can get that in March, you think, or?
It won't be in March. It'll be that. I guess I calculated wrong and I thought it was 12 that I owe. I'll be able to give 500 on Tuesday. And then the following Friday, I'll try my best to get the rest.
All right, so you're going to pay 500 by the 3rd. I think that's right. Yeah. So you're going to pay 500 by March 3rd. And then you think the balance you might be able to have by the 13th, but you're not sure. Okay.
Right.
Let's do this. Then I'm going to adjourn it out to March 13th, 2026 at 1 p.m. That's in person. If you have everything paid, I don't need to see you. All right. But if not, you'll have to come down to the courthouse. We'll figure out where to go from here. Okay.
Okay.
All right. You have a great weekend.
You too. Thank you.
Hamilton Crossing 2 versus Tierra Warren.
Jillian Engen for plaintiff.
Ms. Warren, hello.
Hi.
Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance included of $1,046.71.
All right. Ms. Warren? How are we gonna get that paid?
So I'm just trying to understand where she got that balance from, because on the judgment I owed $721 by February 8th. I've made in January I only owe $52 left. And I made a payment of $400 yesterday. So I'm not understanding. And when I called and spoke to Daryl at the front desk, he said I only owed $800 and some change. And I paid $400 yesterday. So I'm trying $400 in total. So I'm just trying to understand where she got this balance from.
Your Honor, if I may, I can answer this part of that. So part of that is, Ms. Warren, when we get the ledgers from our client, because it's in the morning, we ask for them the day before, and so I wouldn't have that $400 payment, so I can make a note of that and it would be reflected next come back to court. The other thing is on your ledger doesn't yet reflect court costs, but the court costs are $176.
Yeah, but I shouldn't have a court cost, because if it said on the paper, it said that the judgment was put in at the end of December 31st, which I shouldn't have. My rent was paid through January. I owed $52 in January. That was it. Then February came out. I paid $200 on maybe the 15th of February, just gave another $400 yesterday. So I shouldn't have court fees either, because it wasn't not paid through December 31st. And that was on the judgment, because the original paper said I owed $721 by.
Ma'am, this isn't about the judgment. If you look at the complaint that came in this case, they indicated that you owe $1,130.81 as of February 11th.
Okay. Well, yeah, I don't even owe that.
Okay, but if you owed something in February, then they're entitled to their court cost.
Okay, well, that's fine. But then, so how much do I owe? Because it shouldn't be the 1,000 or whatnot. Because when I called and spoke to Daryl, he said I only owed $800 and something. And I gave $400 yesterday. That's why I was coming here to clear up everything and make sure, because I can make a payment today and I want to pay it off, but I'm not trying to give extra money. I don't have money to just give to them.
Okay. Nobody's trying to give extra money. I get you.
At all. And I tried to call and speak to Jillian on Monday. I called and left a voicemail, never spoke to anybody. I called to the rental office since Monday, never got a call back. So communication is horrible. But I don't have money like that. Like, I'm a single mom of 2 kids. Like, I don't have money.
Ma'am, Miss Warren. All right. I don't know. I had the balance I was given was the $1,046.71. The problem is you paid something that's probably not taken off of that figure. That's what counsel was indicating. So what you paid, you subtract that out. I think where the difference for you is going to be in the court cost. It looks to me like they would be entitled to the court cost. So I think you're going to have to pay that. So let me ask you this, Ms. Warren. How much can you pay today?
I guess I want to know exactly how much I owe, because I don't want it to go over
Ms.
into
Warren,
March.
I'm not going to go around in circles.
Okay, $400. I can give the $400.
Okay, so here's the thing. Pay the $400 today. Okay, it looks like you're probably going to owe more than that, but I'm going to adjourn it out 2 weeks to the 13th. Okay, and then we'll be able to reconcile your payments and all of that into your account, and we'll figure out a way to get you back to zero. Okay.
Okay, thank you.
All right, so I'll adjourn this out to March 13th, 2026 at 1 p.m. All right?
All right, thank
you.
you. They so fucking.
Whoa. Oh, really?
I think
Really?
it was timely, Your Honor. She muted timely.
No, she didn't.
Getting the whole thing out, I think.
You see? Okay, so mark that file. We'll have to talk with her when she comes in. All right, let's go on. Hamilton Crossing 2 versus Lawrence Sharp.
Jillian Ingen.
And
Sorry.
go ahead, I'm sorry.
Jillian Ingen.
Okay. Okay, we'll do it this way.
Mm-hmm.
Lawrence Sharp, Ann Underwood, and Levy Sharp. Go ahead now, miss.
Jillian Ingen for sorry, Your Honor.
No, it's okay. It's probably my fault, but there we go. And I think who do we have? I think Underwood. Hello, you guys want to identify who you are? Can I hear them? Can they hear me? I cannot hear them.
That's Ashley Womack.
Ms. Womack.
I'm not.
Miss Will. No, I got Miss Womack. I haven't called, ma'am. I haven't called your case yet. Okay. So hold on a moment. I see Ann Underwood listed. I see a gentleman that may be, you're Ann Underwood. You're waving at me.
Yes.
And I'm Lawrence, Your Honor.
Got it. Okay, now I can hear you guys. Okay. I couldn't hear you before and I was a little bit worried. All right, what is the claim in the case?
Your Honor, this is a termination of tenancy case. Mr. Sharp is a former employee who took possession without authority, or the application was approved before a lease was signed. And Your Honor is requesting an immediate order and in this matter under MCL 600-5744.
All right. You guys heard that?
Yes, Your Honor.
All right. What's your position?
Well, Your Honor, some of that is correct. I am a former employee. I was an employee
Until they came here with 9 people threatening to move out.
and I did the paperwork as anyone does, and I waited. Our lease was up, so I already had the U-Haul packed from our last apartment, waiting for the okay that I was approved. It took about 5 or 6 days. Finally, I got to go ahead and said I was approved. Now,
so are you going to move out?
No, we don't.
I really would like to stay here. I have the money to pay and everything. I don't.
We don't want to do any more damage.
I hate to move my son around again. He's only 11, and I just don't understand. I moved in a day early. After I got the verbal saying that I was approved, I didn't steal any keys. I had the keys because I will have access to check apartments and stuff. I was told to make sure it was move-in ready. So I did that. I did move in before I paid my security deposit, but there was no one in the office by the time I had the money order. So I was just going to give them to him the next morning. I figured no harm, no foul. And then this happened, and I got fired on top of it. So it's been a rough couple months, Your Honor. And all I'm trying to do is take care of my family, and I'm sober. I've went through all this stuff. I've been clean. I'm going to college. My family actually likes this apartment.
Okay.
Yes,
sir.
Yeah.
It sounds to
Sorry, I'm
me
rambling.
like you may have to vacate the premises. I will give you an opportunity to speak with a lawyer on this.
Yes. Thank you.
I'll adjourn it out to March 13th, 2026 at 1 p.m. But you need to also understand that if I grant them a judgment on that date, that there will be an immediate writ. So there's not going to be like it goes out to then and then you get additional 10 days.
Right. I understand.
My suggestion to you, you can talk with an attorney. My suggestion to you is that you might want to make arrangements to get
Okay.
yourself to another spot so
Right.
that you and your family aren't out.
Sure. Yes, I'm actually already on top of that. I mean, we do like this place, and I would have no problem paying. But if they want me out, then I'll have to get out, I guess. But
I think, sir, I think that's what they want. That's why we're here.
okay. All
All
right.
right, but
Well,
I have to
I
give you an
appreciate you saying
opportunity to speak with an attorney. Okay?
that. Okay. Thank you, Your Honor. I appreciate it.
Thank you. Scio Farms versus James Gotchis. Gotchis? Not checked in, but I think this is your motion.
It is indeed, Your Honor. This is plaintiff's motion. This file, Your Honor. This is the motion, I believe it's for demolition of the home. Yes, to
for
demolish the home
demolition.
on site. And Your Honor, the file should indicate that there was an action brought for non-payment run in June of 2025. A default judgment was granted on June 27th of last year in the amount of $2,273.55. Your Honor, the judgment wasn't paid. An order of eviction was requested, issued, and executed. We were made aware of the fact that the defendant had a guardian. We were in communication with the guardian regarding disposition of the home, but the guardian who was served with a copy of this motion has not been in contact, and the home still is on the site, Your Honor. It is abandoned. The rental balance due and owing to Scio Farms is $10,336.23. Based on that, Your Honor, the age and condition of the home as noted in the motion, we would request entry of an order allowing Scio Farms to demolish it on site.
Bruce, the court will sign the order and grant the plaintiff's motion to demolish the home on site, and I've signed that order.
Thank you, Your Honor.
Scio Farms versus Judith, is it Hassif? You might be saying that wrong. I said, no response. You may proceed.
Thank you, Your
This
Honor.
is also the same thing.
Yeah,
Go
we've
ahead.
got a couple of these up before, I think 3, maybe 4 of these up for Your Honor today. Your Honor, in this case, an action for non-payment of rent was brought by plaintiff in July of 2025. A default judgment entered on August 1st, requiring payment of $3,460 on or before August 11th. Said payment was not made. An order of eviction was requested, issued, and subsequently executed. The home at issue, Your Honor, is a 1987 manufactured home. We discovered that the defendant is deceased. She apparently passed away in 2020, and there was an occupant living in the home, paying the rent and doing all the things. That occupant then vacated and indicated that she had the title and would be bringing the title, but she did not have the title in her name. So while she may have been in possession of the physical title, she was not the registered owner of the title. And I believe it still remains vested in the name of the deceased tenant. Your Honor, we have attempted to reach out to that person as well as the deceased tenant's next of kin. We did make contact with the defendant's son who lives out of state. Your Honor, he had indicated that he really didn't have an interest in the home, that we did inquire about the value. Your Honor, my client's position is that this home has no value. It has not been maintained. There has been burst pipes. The home is significantly damaged, and the rental balance owed to Scio Farms in any event is $7,581.85, which presumably eclipses any minimal value that the home may have. So based on that, Your Honor, we would request entry of an order allowing Scio Farms to likewise demolish this home on site. Your Honor, I would also note that we did serve defendant's son with a copy of this motion, and the proof of service indicates that we served him at his address in Illinois that we were able to locate him at.
Got it. All right. Based upon the proofs, the court is going to grant the plaintiff's motion for removal and demolition of the home on site. And I've signed that order. Spice Tree Apartments versus Affolashade Lawal. I think I got that. I messed it up, didn't I?
It's okay.
What?
I said it's okay. It's Affolashade Lawal.
You just said your name?
Yes.
Really? Slow that down. What'd you say?
Affolashade Lawal.
Okay. I don't know that helped me, but all right. What's owing on this account?
Your Honor, this is actually defendant's motion to set aside a default judgment. The judgment entered, Your Honor, on February 17th for $382. And I believe that's the balance that remains today, but let me verify with the ledger that I have. No. Your Honor, it looks like we did request an order of eviction on this, and there may have been, so we've got her at $616.
616, that's yours?
Yep, that includes charges relating to the order of eviction, Your Honor, that was sought.
All right.
Good morning, Your Honor. So I don't understand why I'm in court first, because they sent me a docket for November rent. I do not owe November rent. My rents are current. However, they told me on the 14th of January, I paid my rent, including the first late fee. I told them that I'm okay paying the first late fee. So I paid the first late fee because I'm a PhD candidate and my funds come internationally. So due to the holidays, I was able to get my fund late. So I paid the rent on the 14th of January, including the first late fee. So on the 15th, the payment was made on the 14th before the 15th. So on the 26th, I received a call from James of Spice Tree. He told me I have a $282 balance on my account. And I requested for the breakdown of this amount. And he told me that it's a $182 court fee and a $10 late fee. So I asked like, okay, can you guys give me a one-time waiver for this late fee? The request was declined, right? So I requested for the official court receipt for the $182 because I paid on the 14th. So he told me, oh, we filed the case. I asked him, when did you file the case? He told me they filed the case on the 6th of January. And I said, okay. He sent me the ledger. I sent the ledger back to my funders and said, this is what happened. Because you guys disbursed for me late, I have a pending amount, so you guys need to send me $282. So they declined. They said the ledger wasn't allowed, that they need an official court docket. So I came to the court to ask for these details. They told me this case was filed on the 20th. I paid my rent on the 14th. I went back to my rental contract. There is no way on my rental contract that says that they are going to charge me $182 on the 14th of January, even though I paid my rent on the 14th of January. And ever since then, even though this case has been in court, I've been getting harassing messages, and I've also been getting tags on my door that I'm late on rent, even though I'm current on rent. All I requested for, without the additional late fee and all the multiple late fee that they have been adding onto it, is that give me a receipt of the court fee that you paid to the court on the 14th of January. Because as per the court, I came to the clerk, I went to the court clerk. This case was filed on the 20th of January.
Your Honor, the demand for possession was issued on January 6th, meaning that payment of the balance due was needed by close of business on the 13th. It was not made by defendants and statements. Our complaint is dated January 14th and would have been processed by our office and sent for filing with the court on that date. I understand the court may not have received it and processed it until the, I don't know what date the court marked it as received. I don't see a date stamp on here as far as the date it was received, but I see the date it was issued by the court was on the 22nd. And so these court costs were properly incurred. The payment was due by the 13th. It didn't happen. It was referred to us for filing, and my client did incur these costs to recover the monies that it was owed. So,
Your Honor, can I ask her a question, please?
Yeah.
Okay, so my question is, why was I filed for the 20th of November if you guys were not trying to represent in the court? Because here it says, it says that I'm current up until 30th of November. That's what it says in the initial filing for the non-payment of rent.
In this case?
Yes.
and Your Honor, I can explain she's referring
You mean
to
the pro rata amount on the complaint?
Yeah, so Your Honor, she's looking at the date under 5C, rent is paid through 11/30/2025.
Yeah.
And the way that calculates, Your Honor, is it looks at the total balance due, and if it exceeds however many months of rent, then it dates it back because there are additional amounts owed over and above just the base rent of the $1,500. That being utility charges that are charged and metered based on usage, trash fees. So those additional charges put the balance due over and above what would have been, in this case, presumably the January balance. And in looking at the ledger, Your Honor, we verify if she was paid, in fact, through December at the time the case was filed. And she was, Your Honor. So my client was not seeking anything over and above that, but at the time the case was filed by our office, she did still owe the January charges, late fee, and then the court costs were incurred by my client.
Your Honor, I also have the ledger here, and as at the 16th of January, my balance stays at $282.42, which is the court fee and the late fee that they charged me on the 16th of January. That's what the ledger says here. So how come if it's on the 16th of January, my balance says $282.42, and you are filing in court that my balance is $1,570. $1,570. I also have the ledger here.
Your Honor, I can look at the ledger and say, yeah, that's what it says on January 16th, but on January 14th, the balance was, in fact, $1,856.40.
I paid my rent on the 14th of January.
Do not yell.
I'm sorry, Your Honor.
When they file and sign the complaint, what they alleged to the court at the time of the signing was what was owed on the ledger. You're expecting, in both things that you said, you're expecting the number to somehow change between the time that the plaintiff files it and the time that it gets to the court for filing.
Okay, Your Honor.
The only thing that's required is that the amount or the information that's contained in the complaint is true at the time that it's signed by the attorney's office. And in each of the instances that you're bringing up, it's true.
Your Honor, so if that's the case, if they are alleging that it's on the 1st of January, then the balance, so if they're alleging that they filed on the 14th of January, then the balance should be $1,674. That's what my account says.
If they file it on the 1st of January.
Yeah, if they filed on the 1st of January, like if they filed before then. So because my balance, my closing balance is $1,500 on the 5th of November, on the 5th of December, right? And on the 1st of January,
now, what do you want to have happen here?
Okay, so what I requested for is that I just want them to give me the receipt dated on the 14th before I paid that it was filed on the 14th.
You mean before you pay the court costs?
Before I paid the rent, because I paid the rent on the 14th.
You want the receipt on the 14th?
Yes. Like, because I need to get this money reimbursed back to me if I'm to pay. And they say
money reimbursed back.
Okay, so they're saying that okay, sorry, I'm gonna come again, Your Honor. I'm really sorry. So I paid my rent on the 14th of January. And they are telling me that I paid my rent late on the 14th of January. So I'm going to be charged $182 for the court fee. when they
Oh,
called me.
you're being charged a court fee because if those things cross in the mail, they cross in the mail. I mean, quite frankly, and I don't say this to people, but you're trying to argue some timing technicality, which doesn't make any sense to me. Because the cold-hearted reality is, had you paid your rent on the 1st of November, or 1st of January, we wouldn't even be here. We wouldn't even be arguing about it.
Yeah, Your Honor, I paid, that's why I paid the late fee. Because I understood the late night.
Right, but right, you can pay the late fee, but the plaintiff has the right to pursue whatever they can pursue in court and need to protect themselves.
Yes, but according to the contract, they told me that I should pay before the 14th and then the late fee will apply. Your Honor, I paid this from my pocket when I had additional job. But right now, the only fund I have is for my funders. So I do not have additional income to complement this. I'm okay paying all of this. But if my funders tell me we need these papers so that I can get this money from them, that's all of from my fund. I'm a PhD candidate at the University of Michigan, and I get my funds from an international organization that is paying my living allowances and my rent.
And Your Honor, if I may, just to touch on one thing, defendant indicated that they told her to pay before the 14th, which is accurate. If she had paid before the 14th on the 13th, when the demand expired and required payment by, we also wouldn't be here today. The issue is that she paid on the 14th, which is not before the 14th. Your Honor, with respect to this, the judgment that has entered in this case should be sufficient for her to take to her fund and say, the court has ordered me to pay this. This is the funding I need to be reimbursed so I can have the rent cured and my housing housing remain in good standing. I don't know what sort of receipt could otherwise be provided, other than, a judgment that acknowledges what's due and owing in order to satisfy the balance owed to Spice Tree.
Because on the judgment, this says I have late rent. So nothing on the judgment says that I'm paying late fee. Because to them, they are saying it's late rent that I stated on this judgment. I sent this to them.
Sent to who?
I sent it to the company that funds my research.
Okay, and they won't pay it?
Yeah, they are telling me that they need to see that this was filed on the 14th, because I sent the rental contract to their lawyers, and they're like, okay, you explain to us that if this is late by the 6th day, because the guy called me on the 14th and he told me you need to pay this by card, because if you go pay by money order, it's going to be delayed. So that's on the 14th morning. So on the 14th, I got back from school at around 8 p.m. ish, and I paid it immediately because he said, if I do money order, it's going to spill to the next day, which is going to be 15th. So I went to make sure that I paid it on the 14th, because he called me on the 14th in the morning of 14th.
And Your Honor, the complaint is the date of that. It says January 14th is the date that the case was processed for filing. That's the only receipt that can be provided to her as proof that legal action was pursued because the payment wasn't timely made. That, in conjunction with the judgment, should be sufficient for that. I mean, the judgment in and of itself is an order of the court saying it has to be paid.
That was sufficient, but when excuse me, that was sufficient, Your Honor. But when I requested from Spice Tree.
Okay, but hold on a second. The issue here doesn't have anything to do with Spice Tree.
He has everything to do with me.
Pardon?
It has to do with me.
I know. So I'm not sure. Spice Tree, everything has been done properly. The fact that, and I don't know what to tell you, the fact that they won't reimburse that, because I don't know what math they're doing. But it would seem to me that if they reimburse your housing costs, if you got a ledger and sent it to them, that should tell them.
Yeah, because I told them, they said a ledger does not constitute that the case was filed in court. Because I'm having this back and forth with them also.
I hear you, but I don't know what anyone can do for that. because you have there's the complaint that was filed. And on the 14th, what's stated on that complaint is that balance. Now, there may have been the crossing of the amounts, but I don't know why they won't pay it. But that doesn't seem to be Spice Tree's problem, quite frankly, as I'm listening to it. And
Yeah,
to be honest with you, not the courts.
I get it, because I think the problem with them is the fact that they are feeling like the papers I submitted is inconsistent with the information Spice Tree is giving me. Because Spice Tree told me this case was filed on the 6th, right? That was the email they sent to me.
No, the notice you get a demand to pay on the 6th. If you look at your paperwork.
Yeah, I did. I got a demand to pay on the 6th. So that was why I
It
sent
expires
that
on
to
the
them.
13th, which is why you need to pay before the 14th. And on the 14th, they proceeded with the balance that was due and owing at the time. So why these people won't do something, I don't know. And I'm not going to order the plaintiff to do something, which is not what they did everything correctly.
Okay, so I'm just going to request from them if they can send me like an email that says like, this is the actual amount or something. And like as part of the
actual amount of
like of the $282 and the date they filed, if they can give everything to me.
You got a judgment.
Yeah, I sent the
382.
Yeah, I sent the judgment to them, and they still said the same thing.
I don't know what you want me to do. They're not under the jurisdiction of this court. That you got a judgment. The judgment says this is what you owe.
Okay, I would proceed with the payment of the judgment.
Pardon?
I would proceed with the payment of the judgment then. Because they are just giving me a lot of it's a back and forth with them.
Okay, but I can't do anything with it. So you're going to, so you filed a motion to set aside the default. When I look at everything, you haven't stated the basis to do that. The motion to set aside is denied. And the judgment will stand. What I'm going to suggest you do is pay off the judgment and then deal with those folks. But there's nothing, I'm not going to order Spice Tree to do something that they don't need to do. And I can't just order people to do stuff. All right, thank you. All right, so that's it. Thank you, Bates. Thank you. What's your name? Anna. And thank you, Rasan. Thank you guys very much. And Ann and Alan's absence for keeping me under control. I do appreciate it. And now I'm going to lead the bench and go rogue. 14.
And thank you, Kier. Thank you, Katie. Thank you, Mama. Thank you, Rhonda, wherever you are, and Felix, and Mark, and JB, GP, Full Metal, Lori, Granny, everybody's names I can see on the screen right now. Oh my Lord. Everything is falling apart on me. Ladies and gentlemen, I know exactly how Judge Simpson feels. It's been a day. Started off as a day, and man, it's ending as a day for me. I got to get this stream stopped so I can restart this computer because ain't nothing working the way it's supposed to. But hey, we've made it. We've made it, ladies and gentlemen. And it was a great stream. I do appreciate everybody in chat. You are all amazing. I do want to give a special shout out to my great friend, Zach, for his support today. As always, the man is a mensch. What can you say? Can't say enough about the Law Nerds. Law Nerds Unite. Make sure you check him out. Hutch is out there somewhere too. Check him out. Hutch has a video coming out later, so go check out that video. Actually, it should be coming out in like 30 minutes or so. Something like that. It may already be out now. May have come out actually like 30 minutes ago. Wait, I think I said 30 minutes ago. Anyway, I'm your lone wolf Usul. I'm crazy and I am spun out of control because I'm having technical problems on my computer, and all I know to do is restart it, which I can't do while I'm streaming. So ladies and gentlemen, thank you for hanging out with me. Come by every night of the week around 8 p.m., 9 p.m., 8 p.m. Central, 9 p.m. Eastern. And we do this, what we're doing right now, every single weekend on Saturday at 11 a.m. Central Time, noon Eastern Time. And I welcome everybody to come hang out and check out these court cases that I find from around the internet. These have been the best from this week. And every night of the week, we have the best of the day for the most part. So come on, hang out, check out. I have regular videos coming out too. I've got tons of videos to put out. I just need time to put them out. So hang out. Happy to see you. I'm your lone wolf Usul, and I am out. Oh, and there's not gonna be a Ferris Bueller thing today. It's just not gonna happen. Can't. Bye, Katie. Bye, Mom. Oh, Mom, I'll see you in a few. Bye, Math Girl. Bye, Patrick. I don't know which one of you said you didn't believe me about the Ferris Bueller thing, but